In absentia is Latin for in the absence. Its meaning varies by jurisdiction and legal system. In common law legal systems, the phrase is more than a spatial description. In these systems it suggests a recognition of a violation to a defendant's right to be present in court proceedings in a criminal trial. Conviction in a trial in which a defendant is not present to answer the charges is held to be a violation of natural justice. Specifically, it violates the second principle of natural justice, audi alterum partem. In some civil law legal systems, such as that of Italy, absentia is a recognized and accepted defensive strategy. Such trials may require the presence of the defendant's lawyer, depending on the country. Europe. Member states of the Council of Europe that are party to the European Convention on Human Rights are bound to adhere to Article 6 of the Convention, which protects the right to a fair trial. Trials in absentia are banned in some member states of the EU and permitted in others, posing significant problems for the fluidity of mutual recognition of these judicial judgments. The executing member states possesses some degree of discretion and is not obliged to execute a European arrest warrant if the country that is making the request has already tried that person in absentia. Conditions under which trials in absentia must be recognized include: if the person can be said to have been aware of the trial, if a counselor took their place at the trial, if they do not request an appeal in due time, and if they are to be offered an appeal. The framework decision on the European arrest warrant provides for the legal guarantees relevant to trials in absentia, while the framework decision explicitly refers to Article 6 of the European Convention on Human Rights. Its purpose is not to harmonize national laws on trials in absentia but to provide terms for the non-recognition of an EAW and other cooperative tools. The framework decision provides detailed conditions and requirements on which a trial in absentia can be considered compatible with Article 6. The right to a fair trial. According to Peter Klepper of the think tank Open Europe, in parts of Europe, in absentia trials essentially give defendants the ability to appeal twice, asking for a retrial at which they would be present and then potentially appealing the second verdict. There are some guarantees in the legal system that make sure that it's fair, that the rights of the defense are not being violated, while still making sure that justice is being done. In absentia judgments are common, you can criticize that, but it's quite common. Peter Klepper, Open Europe. The Council of Europe has made commentary on judgments that are made in absentia. The Committee of Ministers, in Resolution 11, of the 21st of May 1975, stated that an individual must first be effectively served with a summons prior to being tried. In this sense, the ministers are emphasizing that it is not the presence of the accused at the hearing that is of importance. Rather, the focus should be on whether or not the individual was informed of the trial in time. In a 1985 judgment in the case Calosa v. Italy, the European Court of Human Rights stressed that a person charged with a criminal offense is entitled to take part in the hearings. This entitlement is based on the right to a fair trial and the right to a defense, both of which are required by the Convention and 6. Furthermore, the court stressed that a person convicted in absentia shall be entitled to a fresh trial once he becomes aware of the proceedings. When domestic law permits a trial to be held notwithstanding the absence of a person charged with a criminal offense, who is in Mr. Caloza's position, that person should, once he becomes aware of the proceedings, be able to obtain, from a court which has heard him, a fresh determination of the merits of the charge. European Court of Human Rights, Caloza vs. Italy. Belgium. The Human Rights Committee examined Mongeir M. Benj v. Zaire, in which the applicant was sentenced to death in Belgium and was only able to learn of the case against him through the media. Due to these circumstances, the committee found that a number of the applicant's procedural rights had been violated, especially in consideration of the fact that the Crown had hardly attempted to contact the applicant despite possible knowledge of the applicant's address. This highly impeded the applicant's capacity to prepare any form of defense. Failed evidence to support the case that a court had tried to inform the accused of proceedings against him, her provides the committee with the opinion that the right to be tried in one's presence was violated. Czech Republic under Article 8 of the Charter of Fundamental Rights and Basic Freedoms of the Czech Republic, which has the same legal standing as the Czech Constitution. No one may be prosecuted or deprived of their liberty except on grounds and in a manner specified by law. In general, the Czech Criminal Procedural Code requires the presence of the defendant in any criminal proceedings. The code recognizes the following exemptions from this rule: when criminal proceedings may be conducted without the presence of the person charged, where a defendant has died, where a defendant is unknown. This may arise before charges against a person are brought, normally in respect of pre-trial proceedings. For example, if police conclude that a crime has been committed and that action needs to be taken to identify the perpetrator, such as the interrogation of a witness or an identity parade. Such an action is taken in the presence of a judge because the rights of the criminal suspect cannot otherwise be adequately protected during the evidence gathering. Normally, a defendant enjoys the right to be present or represented by an attorney during the interrogation or identity parade. But where the defendant is not yet identified, in order to secure full legality and impartiality, a judge is present. This ensures the admissibility of the resulting evidence will not be successfully challenged during the trial. Typically, this situation might involve a dying witness, not expected to be available later for cross-examination at a trial by or on behalf of the defendant. When confiscating property involved in criminal case from an unknown owner, the property confiscated will remain the property of the unknown owner pending a trial and a court decision to transfer the property confiscated to the state. An example could arise where the property to be confiscated might endanger people, property or society, or might be used for commission of a felony. Typically, this concerns prohibited weapons or ammunition, explosives, narcotics, poisons, etc., seized by the police without, at the time of the seizure, knowing the owner's identity. Where a defendant is known, where an accused person is evading proceedings by being either abroad or in hiding, the proceedings may be conducted in absentia. The proceedings are then officially started by the formal delivery of charges to the defendant's attorney. If the defendant does not have an attorney, the court will appoint one. An attorney must in these circumstances be appointed throughout the entire proceedings, and will have all the defendant's rights. All documents intended for the defendant will be delivered to the attorney and the court must take appropriate measures to announce the trial publicly. Where the absent defendant subsequently appears during the trial, the proceedings shall continue in the normal way. The defendant may request that any evidence that had been presented in his absence be presented again. Where this is not possible, he will be shown records of it and may comment on it. Where the case has ended with an enforceable judgment, the convicted party may request a fresh trial within 8 days of the delivery of the judgment to him. The fresh trial may not lead to an outcome that would be less favorable to the defendant than the outcome of the previous in absentia trial. Apart from the aforementioned cases of in absentia proceedings in the narrow sense, the defendant may also be absent during the trial under following circumstances. When the defendant fails to appear for the trial, only if the indictment was duly delivered and the defendant was duly summoned for the trial and the defendant has already been formally questioned during pre-trial proceedings and the defendant has been alerted about their right to study the case file and to put forward motions for investigation and the court determines that, despite the defendant's absence from the trial, the case can be reliably decided and the purposes of the trial achieved. When the defendant requests that the trial takes place in their absence, if the defendant is being held on remand, a simple failure to appear is not permitted. The defendant must formally request that the proceedings to take place in their absence. When the defendant is disrupting the proceedings, Trial in absentia is possible only on basis of a formal ruling of, and subject to previous warning by, the court, and only for the necessary period of time. Immediately after allowing the defendant back into the courtroom, the presiding judge must convey the essential content of the proceedings taken in the defendant's absence, so as allow them to comment on it. Italy is one of several countries in Europe that allow trials in absentia. Trials in absentia are not infrequently held in Italy. In Malecki v. Italy, the United Nations Human Rights Committee held that the Italian policy on trials in absentia was a breach of the right to fair trial under Article 14 of the International Covenant on Civil and Political Rights. Italy argued that where a defendant in absentia is represented by court-appointed counsel and where he or she has an opportunity to be retried, the right to a fair trial will not be violated. However, the committee disagreed, describing Italy's position as clearly insufficient to lift the burden placed on the state party if it is to justify trying an accused in absentia. It was incumbent on the court that tried the case to verify that Malecki had been informed of the pending case before proceeding to hold the trial in absentia. Failing evidence that the court did so, the HRC is of the opinion that Malecki's right to be tried in his presence was violated. In 2009, a former CIA station chief and 2 other Americans were tried and convicted in absentia by a Milan appeals court for the abduction of Egyptian terror suspect Osama Hassan Mustafa Nasser. The decision meant that 26 Americans tried in absentia for the abduction were found guilty. The highly publicized trial of American Amanda Knox for the 2007 murder of British student Meredith Kercher has highlighted the issue of Italy's willingness to try defendants in absentia. In 2013, Italy's highest court, the Court of Cassation, decided to annul Knox's appeal, thus overturning their previous acquittals, declaring the acquittal as full of deficiencies, contradictions and illogical conclusions. As Amanda Knox remained at her home in the United States, her appeal was heard in absentia, in Florence, Italy. On 30 January 2014, her guilty verdict was reinstated for the murder of Kercher and her sentence set at 28 years and 6 months imprisonment. In the case of Godda v. Italy, the Strasbourg court held that the failure of Italy's judiciary to inform the officially appointed lawyer of the applicant in regards to the correct date of the trial hearing deprived the applicant of an effective defense, and therefore Article 6 had been violated. Certain case law supports the notion that in some circumstances representation by counsel at the trial will not be enough to make an in absentia conviction conclusive enough for the establishment of probable cause. In Garlina v. Fraser, the appellant Vincenzo Garlina was convicted in absentia according to established Italian procedure for 2 robberies. The verdict in Garlina has been since interpreted to suggest that the presence of legal counsel alone is in certain cases insufficient to give an in absentia conviction that establishes probable cause. United States of America. For more than 100 years, courts in the United States have held that, according to the United States Constitution, a criminal defendant's right to appear in person at their trial, as a matter of due process, is protected under the 5th, 6th, and 14th Amendments. In 1884, the United States Supreme Court held that the legislature has deemed it essential to the protection of one whose life or liberty is involved in a prosecution for felony, that he shall be personally present at the trial, that is, at every stage of the trial when his substantial rights may be affected by the proceedings against him, if he be deprived of his life or liberty without being so present. Such deprivation would be without that due process of law required by the Constitution. HOPTV. Utah 110 U.S. 574-28, L. 262, 4S Court 202. A similar holding was announced by the Arizona Court of Appeals in 2004. A voluntary waiver of the right to be present requires true freedom of choice. A trial court may infer that a defendant's absence from trial is voluntary and constitutes a waiver if a defendant had personal knowledge of the time of the proceeding, the right to be present, and had received a warning that the proceeding would take place in their absence if they failed to appear. The courts indulge every reasonable presumption against the waiver of fundamental constitutional rights. State v. Whitley, 85 p. 3d 116. Although United States Congress codified this right by approving Rule 43 of the Federal Rules of Criminal Procedure in 1946 and amended the rule in 1973, the right is not absolute. Rule 43 provides that a defendant shall be present at the arraignment, at the time of the plea, at every stage of the trial including the impaneling of the jury and the return of the verdict, and at the imposition of sentence. However, the following exceptions are included in the rule. The defendant waives his or her right to be present if he or she voluntarily leaves the trial after it has commenced. If he or she persists in disruptive conduct after being warned that such conduct will cause him or her to be removed from the courtroom. A corporation need not be present, but may be represented by counsel. In prosecutions for misdemeanors, the court may permit arraignment, plea, trial, and imposition of sentence in the defendant's absence with his or her written consent, and the defendant need not be present at a conference or argument upon a question of law or at a reduction of sentence under Rule 35 of the Federal Rules of Criminal Procedure. Indeed, several U.S. Supreme Court decisions have recognized that a defendant may forfeit the right to be present at trial through disruptive behavior, or through his or her voluntary absence after trial has begun. In 1993, the Supreme Court revisited Rule 43 in the case of Crosby v. United States. The court unanimously held, in an opinion written by Justice Harry Blackmun, that Rule 43 does not permit the trial in absentia of a defendant who is absent at the beginning of trial. This case requires us to decide whether Federal Rule of Criminal Procedure 43 permits the trial in absentia of a defendant who absconds prior to trial and is absent at its beginning. We hold that it does not. The rule declares explicitly, the defendant shall be present at every stage of the trial, except as otherwise provided by this rule. The list of situations in which the trial may proceed without the defendant is marked as exclusive not by the expression of one circumstance, but rather by the express use of a limiting phrase. In that respect, the language and structure of the rule could not be more clear. However, the Crosby Court reiterated an 80-year-old precedent that where the offense is not capital and the accused is not in custody, if, after the trial has begun in his presence, he voluntarily absents himself, this does not nullify what has been done or prevent the completion of the trial, but, on the contrary, operates as a waiver of his right to be present and leaves the court free to proceed with the trial in like manner and with like effect as if he were present. Diaz v. United States, 223 U.S. at 455, 1912. Some state laws provide for automatic retrial of fugitives who are arrested after being convicted in absentia.